We are going to do that under 184(3). Zara sa soch lein, kyunki like you said, it could have someone is taking pictures of your child. Would you want that?
That is,
even if the child is not in your home, would you, in a park, would you like someone taking pictures of your child?
No, sir.
So don't do it.
बिल्कुल.
You can complain and it may come to haunt you.
Sir, अगर आप section 24D देख लें, when they want, they specifically define it.
No, you do it. You define it.
जरा अगर देख लें, sir, section 24D.
24?
D.
B or D? B. It's a B. D to hai.
D. 24C and 24D.
No, that's an extreme case. Let's not go there. I'm talking about normal. Your child is playing football in a field or cricket or whatever. Would you want your child picture taken?
D covers that also, sir. अगर आप 24D cyber stalking वाला जो है, take a photograph or make a video of any person and distributes it or displays or distributes it without his consent.
मुझे तो नहीं मिल रहा ये. 24 D sir.
Small d sir.
24 A B D का. Okay, small B. अच्छा okay.
जी sir.
वो मैं alphabet अच्छा okay fine. हाँ okay.
Take a photograph or make a video of any person and displays or distributes it without his consent in a manner that harms a person. ऊपर फिर है watch or spy upon a person. C में watch or spy upon a person in a manner that results in fear of violence or serious alarm or distress in the mind of such person. Now, if
so you are saying that 24 attends to all privacy issues.
It attends to some of them. There may be other legitimate privacy interests, but in order to protect them, they have to actually formulate a specific law protecting a specific thing. If you just say that anything that breaches privacy is illegal and punishable with imprisonment, that is an overbroad, overgeneral curb on the freedom of speech. That falls afoul of Article 19 as per the case law developed on this subject.
Can you articulate something precisely on this? You don't have to do it now. You can file something on this privacy, keeping in mind what 24 hasn't already covered. So those kind of things, or we can come back to it. So can we move ahead?
Sir, bilkul. Sir, as far as Article 19 is concerned, as I was saying before your lordship, sir, that
in your petition you don't challenge this, or do challenge?
My lord, I have pointed out that this the privacy aspect of it has not specifically been dealt with, sir. The privacy aspect of it, but Article 19 obviously has been reverted to, sir.
Again, there are two ways to do something. One is to strike down something.
Yes.
The other is to read down something. The third is to interpret something. Our interpretation also in a way becomes a law. So keep all these three aspects in mind, because I don't think we should do striking out, but maybe we can do the next two. Unless you can persuade us otherwise.
My lord, let me begin with Article 19, sir. Sir, उसमें तीन चीजें important hai. One is that the exceptions to freedom of speech is
reasonable.
One, that it has to be reasonable. Number two,
by law.
It has to be imposed by law. Number three, it has to meet one of the 7 objects mentioned in it.
I find 8, you find 7.
My lord,
let's start counting them. Glory
of Islam, integrity, security or defense, I treat them as one, sir. Two, friendly relations with foreign states. 3, public order. 4, decency or morality. 5.
No. Decency is different from morality.
then it will be 8. So
Okay.
I treated decency and morality as part of the same, but then it will be 8.
I know there's common ground, but I think they are two different.
ठीक है, sir.
And if the Constitution has used two different phrases,
Fair enough,
who are we to
Fair
dilute their...
Fair enough, sir. Then in relation to contempt of court, and then this is important, sir, commission of or incitement to an offence.
I think this is the most important one.
Yes, sir. Because your lordship will appreciate that before the 4th constitutional amendment, this specifically included defamation. Defamation was omitted. Defamation was, instead of commission of, it used to be defamation or incitement to.
Defamation was there in the original Constitution.
Ji, sir.
And was removed by the 4th Amendment.
Ji, sir.
When was the 4th Amendment?
So that was 1975.
21st November 1975.
And removed
21 November 1975.
by 4th Amendment.
Ji, sir.
4th Amendment. 21 November
1975.
1975. Theek. Got
Now,
it.
incidentally,
What was the reason for doing so?
my lord,
Did you see the whatever the debates or anything like that?
I have not been able to look at the debate, sir.
Okay.
But if I saw the 1956 Constitution,
Then I can think of reasons myself, wondering what had prevailed by the Constitution makers to do so.
sir,
Theek.
I've not been able to lay my hands on the debates yet, but it was there in all. Defamation was there in all the previous constitutions. It was there in the original 73 Constitution, but it was removed in this, in the 4th Amendment. Now, my submission is, sir, that the purpose of that removal is to decriminalize defamation, and that is the international trend, that defamation is in many countries where they had criminal liability.
Mr. Salahuddin Ahmed, there's another case pending before this court, case of two very famous Pakistani singers, where one alleged sexual harassment against the other, and the other resorted to criminal defamation. And one of the questions posed in that is exactly what you're saying. ये है आप क्या reported
Misha Shafi's and
नहीं वो
Ali
reported
Zafar's,
है या उसका प्रिंट आउट दे दें नहीं उसमें मेरे ख्याल में एग्जैक्ट एक क्वेश्चन आया so we can leave it for that because ये है हमारे पास अच्छा चल I'll continue.
My lord, this is important actually, that case also, and I had advised at least one person who received an FIA notice in that case as well, for expressing support for what Misha Shafi had said on Twitter or Facebook.
Let's not argue that case.
I'm not arguing it. I'm not arguing
let's
it.
not
What I'm saying is that Section 20 was applied in that case as well. Notices were sent by FIA on that ground as well. So what I'm saying is that the criminalization of defamatory speech, whether it be done through Section 20 of PICA or otherwise, that would itself fall afoul of the Article 19.
No, I was just thinking, shall we leave it for that? We're just trying to get the order and just see if it covers what you are going to say.
Sir.
Because it has not been decided. So I don't want to make that petition redundant. Because this very specific question was formulated therein. So can we proceed in the meantime if they can just find it and give it to you?